you worried that your ex is trying to strategically order the way you negotiate your property or children's matters so that they can get a better outcome? Today's episode, we're going to be talking about that. Before we get started, though, a reminder, Mum is not your lawyer. She is a family law accredited specialist and she is a family lawyer with over 35 years experience, but she's not your lawyer. So please get independent legal advice before you make any decision about your case. Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Hi, Mum.
Hello, Laura. Hello, listeners. It's a tricky one today. It's tricky. I always say that, but it is a tricky one.
We're talking about there's a couple of things we hear. One thing here is my ex won't negotiate property at all until I've negotiated parenting and they feel like they're being held to ransom. Then you have the other people who are like, I don't know which one to do first. Is it strategic to do one and not the other, or is it better to do both of them at the same time? That question for people in mediation, negotiating out of court, and then also the people who go to court. They're like, which one should I do? Should I do them together? Range of questions when it comes to the order of what together, separate, or which one first. So today we're going to explore all of that. And we're also going to get into some of the dirty tricks that we're seeing playing out currently in circles where I think they've added this to their new playbook. So we're going to talk about what you can do when it comes to weaponized urgency, the generosity trap, the mediation ambush. We're going to go through all of that. But let's get into firstly, Mum, so that people can get their heads around it. Does the order matter at all?
It matters.
Just blanket. We'll
not
get
much.
Into it.
No, it doesn't. It depends on your own case.
Okay. You'd think it's separate. You would think that everything is in its own place, but they do seem to collide in a couple. And we have talked about this in a depth on the hidden connection between property, and we're not going to talk too much about it today. So if you want to hear more about it after Mum explains it, go and listen to that episode. We're just going to touch on it today. So, Mum, where does property and parenting collide
or correlate? I like that option. They collide in a couple of places, right? As far as parenting goes, the property settlement is rarely an issue, okay, how much you might get in property, because there's no real reflection in the children's Section 60cc on what each parent earns and their ability to provide a house. So where it collides is children impact property settlement in accordance with the Family Law Act. So it impacts perhaps what percentage of property you might get if you've got more or less of the children. It impacts how much child support you might pay or receive if you've got the kids, although that's another issue. And it also, if you're trying to keep a roof over children's heads and you are the primary carer, then a court under the new legislation is able to consider ways of dividing the property that allow you to keep a roof over the children and provide housing. And that would be like, I suspect, ranging in the percentages to be a little bit more generous to the person wanting to house, or perhaps having them take more cash and less superannuation. So, those are the areas.
So you're saying if you figure out children's matters first, and let's just say you have the children 100% of the time, that can affect child support. It's going to affect future needs in your property settlement, and it could affect the housing decision of what happens to the house or in your property settlement. But what you're saying is the other way around. If you get your property settlement first, it doesn't really have any bearing on your children's decisions at all for property, for children's matters. Yeah. Okay. So the only order that could affect the outcome of the other one is if you do property first. If you do children's first.
Yes.
Right.
And I've got a sneaking suspicion that a lot of people who are insisting on doing children's first are trying to buy time so that they become more prominent in the kids' lives and perhaps get their percentage care higher. And a lot of the people who won't go out of when they're living in under one roof won't go till there's a parenting plan. But the subtext of that is until there's a parenting plan that says 50-50. That's what they're doing it for, I think, a lot.
I also think, this is my thoughts of what I've been hearing in the members groups, I think there's people that are saying, I won't do property at all until parenting is sorted, because they don't want to do property. They don't want to have to give away their money or what they see as their money. And they know that parenting is going to take a very long time. And I also think they don't want to do property before parenting because of all of the ones you're going to really dig your heels in and fight for, it's going to be for your children, not for a piece of furniture, not for an extra 2% in the property pool. You are going to dig your heels in for the children. And you are likely, if you have to go to court, willing to spend as much money as possible to get what's best for your children. If it's unsafe or if there is really danger for your children, you may be that kind of person who, and they know that. So they don't want to give you a property settlement because they're worried that it's allowing you then to get proper legal advice. It's allowing you to have the confidence to negotiate better. And people who are on an uneven keel of financials have the money. They're uncertain about where they're living, who's going to pay the next bill. They're not in the right mind frame to be negotiating the kids' stuff. And so they're trying to weaken people, I think, in abuse, coercive control kind of space.
In a way, doing that, imposing your view, it must be the children first and it must be 50-50. That is a form of coercive control, and it is also probably a form of economic abuse because particularly if a person's sitting pretty in the house, then they can stall this as long as possible. And it really seems to be people who don't understand the law or who undervalue the contribution their ex has made. I'm just broadly saying all this here. They're the ones who are going to they're the ones who the court will probably find, if asked, who are the ones who have exercised coercive control on a parent. And ironically, coercive control is part of the definition of family violence, and that impacts children's matters because the court has to consider keeping the children safe, emotionally and psychologically. So you wonder then if just sitting there and refusing to negotiate, unless it's 50-50 children's matters or parenting plans, that should ultimately find its way to the judge, before the judge, even if it's trial.
If you don't get weakened and you don't want to give in and you want to go to court, that's the catch. So I do think there's a lot of people listening here whose exes are basically holding them to ransom, saying, I'm not giving you any dollars at all, ever, until you give me what I want with kids. And so that is, unfortunately, and we're going to talk about that a little bit later, the ransom strategy. So we'll talk about that in a bit. But also be mindful, guys, maybe no one has thought about this. Maybe just run this through your head. What are your deadlines? Are they delaying negotiations and not doing property because they're hoping your time's going to run out? So, Mum, could you just quickly give a reminder of timelines?
Yes. So if you've been de facto, it's 2 years after separation, but you need to lock down separation date in agreement with the other person. So you've got up to 2 years post-separation and you've got to somehow prove separation date. The second one, if you're married, it's 12 months after your divorce. And it's technical. Have a look at what it means. And guys, if you're going to court, give yourself lots of time to get into court.
So you can delay kids' negotiations and you can go to court for kids ages after separation.
Yes.
But when it comes to property, there's only a certain amount of time you have after official divorce, which is 1 year, or 2 years after de facto separation. So make sure that they're not trying to trick you into not negotiating something that actually has a deadline and a timeline.
So you've got your one thing the tricky ex is doing is kind of draining the money. The other one that they may be doing, is trying to run the time out. But I think the third one also applies, particularly when there's an imbalance of power, not a level playing field. And that is that they use the time that they tie you up in children's matters to rearrange their financial affairs. And usually they're not required to make disclosure about property if the negotiations are only about children's matters. So there's a lot to be said for raising that good and early and asking them to start making disclosure as soon as possible.
All right, let's talk about running them together.
Okay.
So can you do both at the same time? Is that normal? Do most people do property and parenting, negotiating that together?
Yes. You'll see in the application forms if you're applying just for financial this, if you're applying for parent just for that, if it's both, complete the whole document. So it's quite common.
If you're negotiating with your ex at mediation or through lawyers, is it okay to do both?
Yep. It's okay to do both.
I've heard of people ask this question, so I'm going to ask you today in case anyone's thinking this. So their lawyer's been writing about property settlement.
Yes.
Or kids, but they haven't mentioned the other thing. And they say, is it okay? Can I raise property settlement, or do I have to wait until someone says something about property settlement? So if you're negotiating with your ex's lawyer, are you allowed to bring up one or the other if they haven't brought it up yet?
Of course. Yep, you can. You can.
Okay.
And it's kind of like, and while we're at it, this is what I want for property. Let's start our property disclosure and negotiations now.
Okay. So then the other people who were in court, their exes filed in court, they said, I'm taking you to court about kids, or I'm taking you to court about property. But that's all they filed about. And then they're now going to file their response. Can property as well, or can they include children's as well if the other side hasn't?
Yes, they can. Yes.
Good.
They can.
Okay.
So the response form allows that. So that puts both issues squarely on the table.
Okay. So running it together is the normal way then, I'm guessing, but then strategically sometimes people do one or the other.
Yeah, I think, or sometimes people are able to sort something out, but they're not able to sort the other thing out. And so it might be just one issue goes to court because that's where they're at loggerheads.
But it does help, I guess, if you're doing both at the same time, to be seeing the whole picture and understanding what's happening and going from there. I can see it problematic for those if you're not too close, if you're really against either of their options for property or children's, trying to go and do a mediation doing both would be tricky. But do you see people doing that? You've done Wilma. Do people manage to get through both if they're very far apart?
Well, they don't always manage to resolve them, but at least you can tick the box that says you've tried mediation and you get your 60I certificate for children. And although the court doesn't have a law that says you must go to mediation for property, you really should try that if it's safe. Yeah, you just go for both and it's normal.
What's the argument then for keeping them separate? Apart from all the dodgy ones we're going to talk about
Dirty
a little
deals.
bit later.
Yeah, dirty deals.
But what is the argument for keeping them separate? Is it cost? Do people just sometimes can't afford to do both?
No, I don't think there's any reason why they keep them separate. If you have to go to court for children's matters, right, and you can't afford to put property in there as well, that might be a reason why you don't go for both. But it's a lot cheaper. You end up with single court appearances where the court mentions both type. The court will go, and about the parenting case, what about what's happening with, and property, how's disclosure going? So it's just something added on to each stage. So yes, but with property, people who want to do parenting first and they're not going to move out of the house or discuss property or any of those things, they have absolutely no right to decree or to rule. They are doing it for a nefarious reason, right? Because it doesn't matter how the property pool splits. The children can be arranged afterwards. And a lot of them are trying to rewrite history by suddenly becoming parent of the year.
Let's get deeds in a minute.
Okay.
But I guess if you've already got a parenting plan and the kids thing is going along okay, you might not need to do parenting at all. That could be a reason. But have you seen any people come to you or can think of anyone off the top of your head who's had any regrets because they did it separately, where they did parenting first and they hadn't done financial, or they'd done financial and they hadn't done parenting? Has there ever been any regrets?
I think so. I think I can see your time starts to run if you've been divorced. That makes it a little bit fraught. A lot of people like to do parenting first, and you'll find most in a trial, say if you end up at a final trial with property and children, the court will normally deal with the children's matter first because children are more important, right? And I guess some people may regret it if they later, after the matter's been running along for a while for children, and then they get to, say, the compliance and readiness hearing and think, well, add property in because it's just going to, otherwise it's never going to get anywhere and it gets sent back. I think that could be a regret, that people add it in too late and then they have to go back to a registrar who will check they've got valuations, see what disclosure's been made. Certainly not out of court, if your lawyer is writing letters back and forth, sometimes I've heard people say that they don't want to talk about property because they're scared that their ex will double down on the children's matters or it'll upset them. But guys, we have to upset them at some stage. You need to speak your truth. And it might be, Laura, it's just a lack of, you're not feeling safe. And therefore, and when they take you to court, it's children.
That's true. And safety, of course, and the fear. And I think the fear of unknown. So I do see with our ladies and our members and some men, they're educated and they're empowered. So they go from, I have to do exactly what their lawyer says and I have to do exactly what they want and the way they want it. And over time in our membership group, one of the things you say all the time, and I think this might be what's embroidered on one of the cushions today, is who died and made them boss? Who said they were in control of how this negotiation is done? And over time, I see our ladies slowly transform into saying that themselves, going, who died and made you boss? Whereas and I was a little bit like that. I was like, the lawyers are saying we need to do this, so I have to do it. It's on official letterhead and they're professionals and I'm just a mum. So think over time, if you can understand the process and why things are done a little bit, you can be like, hang on a minute. You've got to be able to see through that what actually is law and what are they just trying to bluff on you? Because that happens a lot with self-repped.
Yeah, I think so.
And do they do that with junior lawyers as well? Mum, did you ever find when you were younger that the bigger lawyers would be trying, this is the way we're doing it? And you would have to push
my
back?
Goodness. Yes. And when I was a lawyer, there were only about 8 or 9% of lawyers were women. And I got treated quite disrespectfully by senior lawyers, but they only ever did it once. So I only ever did it once. So yes, you can find, if you've got a powerful ex who's a little bit bossy and bolshy, and if your ex is like that, they will always find a lawyer who they can bully for the early stages. And then when things get a bit like going against them, they'll sack that lawyer, they see him too, and then get a lawyer who's a bully. I don't know if that's, I can think of dozens of examples where that happens. Yeah.
And then they just kind of they try to bully, especially the self-reps, into doing what they want by basically saying, I'm a lawyer, you must do what I say. So let's go through some of these tricks we see, because I think we've got a few to go through, and it's important that we touch on these because I don't think anyone talks about these at all. So I'm calling this one the hostage swap.
Yeah.
Okay?
Yes.
And these are the things we're seeing, guys, and I reckon whoever's listening today will already know what this strategy is. I will not discuss the house. I will not discuss the money that I have taken out of the account until parenting is agreed. Or you can sometimes see the reverse. So I'm not discussing this until this is done. And so it's usually the poor kids. You have to somehow give them the kids so that you can have some money. And this happens a lot in the financial abuse, controlling domestic violence situations, isn't it, Mum?
Yeah, I see it all the time. And years ago, one that's really lives in my mind was they actually had the audacity to say, if your client will accept this in dollars, our client will agree to the children living with her. And it's a no-brainer, isn't it, for you? But it was a disgusting thing to say. And I think the most powerful thing that anyone being held in this situation can say is simply, that's not the law, okay? And once they see that you are learning and you have educated yourself, then they can't keep feeding you fibs.
There's nothing in the Family Law Act that says you are not allowed to negotiate property until children's matters are dead. There's nothing there that says that.
Absolutely nothing. Absolutely nothing.
Okay. I guess another thing I want to point out for people who are in this kind of, they hold you to ransom kind of thing, I've noticed that's not always what happens. Sometimes they just then move it to a different condition. I'm now not going to discuss property until we've done this, or I'm now not going to do this until you do this. And then it just slowly becomes this ridiculously long negotiation where they get everything they want just because you're so desperate to get the money. And I've seen people when they're negotiating their what do you call them, their consent orders, well, you want to agree to that. And those people think, oh, that must mean then that once I agree to that, they're going to agree to everything else in the agreement.
Yeah.
But then they don't. But then they say, but you've locked in an agreement saying you will do X, Y, Z. So be careful if you've got these kind of, we're saying, I won't do this until you do this. That is the only time they do it. If you do want to give in, I wouldn't be giving in, but everyone's situation is different. But just make sure they don't keep doing it to you.
a good reality check for people, for you, if you've got the other person putting these ultimatums and strictures on you and conditions and rules, try and imagine you saying those things to them. And if you can't imagine that you could say those things to them, then you are in a power imbalance, probably in a coercively controlling relationship. Okay. And early on in separations, you will feel that you could never say these things. And so if you're just early out of a relationship, they are just continuing the abuse that you've been under. And separated under one roof really worries me, because that is a way where you never get that fresh air to look at things in a different way of looking at it. So yes, it's really tricky. And I think saying that's not the law for some people would be really hard to do. But you said it becomes a long negotiation. I don't know that it's a negotiation that happens. Most people, I think, that we talk to, they talk about, I'm stuck. The wheels are spinning. We're stuck on whether to get a valuation. We're stuck on whether this is the same house or business or not. And some of those things are things that already have been decided at law. And you can, send a case over and let them know that you know what the
that's
law
important to remember that, that you're not. I think it's funny to say you're not unique, but that every possible case you can imagine has happened, and the courts have decided and made decisions on these. So if you can find a case to get yourselves unstuck, it's not some new decision that needs to be made. The decision's been made in the past, and you just need to find an example of one to unstuck yourselves. Now, this is another type of stuck, and I see this a lot as well, Mum. There's 8 of these that we're seeing at the moment. It's the circle walk. The circle walk, I'm calling it, and we've talked about this, where they say property depends on parenting, but then the parenting depends on housing, which then depends on the property. And so they keep going around in this circle and nothing gets agreed on ever happens, because there's this circular argument of, if I'm going to have the kids, then I need the house. But if I need the house, what are we going to do about property? And a lot of the times the circle walk is probably done by an avoidant or a controlling who's trying to delay.
Yes.
And or worse. Yeah. Can you explain something for people going through the circle walk helps that power imbalance again as well? A thing called interim property distribution.
Absolutely. Yeah.
So what is it, and how can it help people stuck in this circle? You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce, or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today. What is it, and how can it help people stuck in this circle?
Okay. And you may have an entitlement. You believe you've got an entitlement, but it's locked into something. It's in a joint account, or they've got it in their account, or it's a redraw on the mortgage or offset account, something like that. And it is part of the property that's going to be distributed ultimately. If you apply for interim property settlement, and if they're in the house and they won't go, maybe you want an order for sole occupancy at the same time. But you could say to the court, look, my ex has all this money, they've got this business, I have nothing, the mortgage is being paid by my ex, but then they threaten to withhold it. So I want some of that money as an interim property distribution for me, so I can pay for lawyers and so I can go to court and get this thing resolved.
That is a circuit breaker. If you can get your hands on some money so that you've got more stability and more power to yourself to fix up that power imbalance, then it kind of stops the circle because they've lost their control.
It's often the first time you've had a win against them, and for them it's the first time they've lost, and that's a little warning for them.
Okay, so do you need to go to court to ask for an interim property agreement, or can you just ask their lawyer?
No, you don't have to go to court for that. You can ask in a letter, identify where the money is, make sure you've frozen it or locked it down somehow, and ask for a certain amount of money to be distributed to you to enable you to get your legals and whatever. You don't have to explain what you want it for. You just need some money, and it's joint money.
That can help you with the hostage swap as well, because if you're desperate and they're insisting on whatever with the kids and you feel like you're going to have to give in because you can't eat next week because the grocery bill is impossible to pay, that interim property settlement can help you. Now, we've got a whole episode on how to do that. Yes. So I will put that. It's things that your lawyer might not tell you about because a lot of lawyers don't do it. So we're going to put that in the show notes for you to listen to it. Can you use interim parenting orders as a circuit breaker as well in that loop? Would it help?
You should only apply for interim orders if it's necessary going forward. So at the moment, what the scenario we're talking about is no parenting plan, no court order yet, right? But if there's pressure, it will usually come from them. If you are resisting, they will probably file in the court and they may well seek an interim parenting order of, say, 50-50 or whatever. So, yes, you can do interim orders about parenting. It's a very high-level overview by the court. They don't know everything, but they probably will send you off to a family report writer within the court and a court consultant, someone within the court, or send you outside to get a 68L family law report from a private person. And that sometimes can be the circuit breaker.
Yeah. I think if you're in a circle walk and nothing's getting done, something done can make a difference. It's taking that next step. Another strategy is the 50-50 care play. Okay, so pushing hard for equal shared. They desperately want 50-50, but they've never shown any interest in it. They haven't even done 50-50 up until this point. They drop the kids off the grandparents. They drop the kids off early. They don't actually turn up for their time.
Pick them up late.
So one of the things that we're seeing at the moment is where they go, it's 50-50. I want 50 of the kids and I'm not negotiating property at all until this is sorted out. But they've shown no interest in actually doing 50-50. They spend more energy fighting in legal letters and court and time than they do actually spending time with the children.
Yeah, and a lot of the time it's untested because they're in the house. They're stuck in the house. So I would say to anyone whose ex is insisting on 50-50 for the children, that your ex is living in the past. The legislation doesn't say that anymore. It doesn't lean towards equal shared parental responsibility or equal shared care. What it is now is the best interests of the children. And it's going to be an examination of who's been doing the right thing by the kids, who did what, who can do it going forward. And if your ex is sitting on the couch with an ability to go, but saying that you're separated under one roof, and they won't agree until the children are sorted out as 50-50, I think that is the perfect example of not putting the children's interests first, right? The kids are living in an armed camp, so to speak, particularly you're either fighting or there's stony silences, and it's very awkward for the children. And so I think the very fact that they refuse to leave until there's 50-50, they don't say until we go to court and get a consent order for 50-50. It's usually we had a parenting plan for 50-50. So, yeah, I think they're demonstrating by their behaviour that they're not putting the children first. And you've got your historical records and you can pinpoint the day that they suddenly decided to try to step up. And if they've been having time with the children, even if it's not 50-50, there may, like you say, there were opportunities that they missed, or they've demonstrated lack of interest or follow-through, lack of follow-through.
All right. Another strategy we're seeing is obviously the disclosure drip, where they're trying to look like they're complying. They're trying to look like they're doing the right thing, but especially if they're manipulative controlling, but they're doing it really slowly. A statement here, a statement there, or just like the cover sheet, but not the entire document. And they're trying to do that as a way to not do property settlement, but just do kids and leave property till last or vice versa. So when you see people doing that kind of dirty trick, Mum, what kind of things can you say to people? What can they do listening today?
First of all, point out to the ex that they have an obligation to make full disclosure. Put in writing and in dot point form the sins they've committed. This page is missing. This was only a cover sheet, a few examples of it. Then remind them of their obligation under Section 71B of the Family Law Act to make disclosure. And then I think I would be also reminding them, reminding their lawyer if they've got one, that the Schedule 1 of the Federal Circuit and Family Court rules says at the bottom of that document, if a client is refusing to make disclosure, then the lawyer should take the appropriate action, that is, cease acting for that client. And so you bring that to their attention each time there's a delay. And there have been cases where the courts have ordered costs against lawyers. And while we're at it, Laura, there are a couple of cases now where if you've got a family violence order and the lawyer contacts you, but it's ostensibly the same sort of stuff you've been putting up with from your ex, you can tell they've written it right, or they've had a lot of input. The professional bodies, like the law societies, are jumping down on these lawyers who are being used by their clients as kind of they called it a cat's paw, right, where they're used to make issues with that. So you've got a lot of power, and you can start to list their failures with disclosure, and then I would be looking then at saying, we can't mediate until I have the documents. But if you're looking for documents about a business, consider whether you would be better off getting it valued instead.
And we've got a great episode on, listen to that episode as well, if that is your situation. And I guess just in general, not just disclosure delay, but just any delay or any avoidance whatsoever. This strategy is called the attrition strategy, but basically it's just delaying. And I see
wear you down,
where they just want you to just be so frustrated and so over it. And how many emails do we get, Mum, from gorgeous, wonderful humans who just want to settle and they just want it over and they're just willing to give up and give in to whatever percentage the other person wants just because they're so over it. How can people deal with those kind of morons? I guess you can use those letters, and we've got that letter template in our course that a lot of our members have used against the Exes lawyers. So aside from writing that letter and sending that letter template, any other things you want to say to someone who's feeling like they just want to give in because this is going on forever?
I would say, darlings, if you're in that position and you feel like you want to give in, ask yourself, can you just let it go for a bit, right? If you haven't started court and you're banging your head against a wall trying to get disclosure and you're not getting it, and you're worn down and you're tempted to accept something paltry, give yourself a week or two off from thinking about it and explore how you feel after that, because you need a break. And while you're a subject usually of post-separation abuse, I think failure to disclose is bound to increase the anxiety of anybody, and it is a way of coercively controlling. While that's happening to you, they're able to reach out to you post-separation and continue their abuse. So if you're not in court and it doesn't really matter, then I would stop looking for documents and I would stop insisting on them giving any documents and just have a break for a couple of weeks. The only time you can't do that is if the kids have to be with them or have to be with you, in which case you will have to negotiate with them. But yes.
Or if you've got your court time limits. But that's it. Also ask yourself, what would you say to your best friend? And what would your future self say to you if they had a time machine and they came back? And would they say, don't give up yet, keep trying? Or would they say, just give in? So some things to think about there. Now, there's another strategy that we hear all the time, Mum, and it's the mediation ambush. So we've got our members, they go to mediation, they've got their property and their parenting stuff, they've got all their information, they've set it all up through the course, they're ready to negotiate, and their ex walks in and says, I'm not talking about XYZ.
Yes, I'm only going to do property, or I'm only going to do children.
What can people do in a mediation ambush? Or how can you stop it before it happens? Or how can you prepare for that?
Yeah, because everything that happens in a mediation is confidential. So you can prepare yourself for them to still be the same snarky person they were. But you can't call them out on it because it happened during the mediation, okay? So in that situation, if you can, before you go, make sure you've got an option to just have the mediation for half a day and scope to extend, because often when you've got someone who's tricky, a half a day, you've already beaten up all of the options and nothing's working, and that'll minimise your loss. You may, if you can, go on your own. So your only expense is the cost of the mediator, not a full legal team, as you might have. And I think that's really about all I think that you can do in that situation, but then immediately follow up with a letter of offer that you had, or put in writing that you want to do property and parenting together, or you want to do whatever one together, and let them respond with, no, I just want to do property, or I just want to do parenting. And then you've got them right outside of the mediation. But
in
the court
writing,
doesn't,
so you can
in
show
writing,
the
that's
court.
right.
Yeah.
Yes, you can show the court. And it's ridiculous. And of course, the ultimate answer, my dears, is to go to court, to file an application, because once someone who is refusing to negotiate or refusing to disclose gets up before a registrar in the court, the laser focus of the registrar is going to be on them, and they're going to get a few home truths, and you may even be able to ask for some of your legal fees to be paid by them because you've had to go to court because they're widows and not doing it. And if it's a valuation, if it's a business, don't bother getting all the documents with the business, just get a valuer appointed. So all the things they refuse to do, a court can order at the first court event, and don't waste too much money trying to change them. And once they feel they're getting close to court, then they know the law. You may find they try to comply a little better.
And I think that's really important. I know a lot of people go, I don't want to go to court, I don't want to go to court. But in mediation, they can't be forced. But just filing an application or your notice of intention to file, which you can also use out in our course, it doesn't mean you're going to go all the way to trial, but it could mean the difference between them just finally giving in and going, okay, I'll negotiate property, because they know going to court, they can't misbehave in the court system, or they can until it's looked at by laser light. But it's a little bit more serious, and there's less run. It's like children in a playground as opposed to children in the classroom. Yes, they're still going to be misbehaving in the classroom, but someone's going to pull them up on it eventually. But children in the playground down the back where no one can see behind the pipes, they can do whatever they want.
Oh, my goodness. You didn't,
and that's the difference. I kissed a boy in grade 3, mother, behind the pipes. But what I'm trying to say is that behaviour isn't going to happen in a court.
Yeah.
And so think of the court like the classroom and saying, hey, we're going back into class. I'm going to dob on you to the teacher. You're not even in the class. You're not even in court. But the thought of that may scare them into doing what's right. So let's get into a different type of strategy, and that's the generosity trap. And they are like, oh, I'll give you this early offer because I'm being so generous because you're so desperate to get money. And then they'll say, I'll give you that offer, but I'll only do that offer and be this generous if you do what I want. So it's kind of like, it's kind of manipulative and controlling, you realizing it. And sometimes that can be a trap. Have you seen that happen, Mum?
Yeah,
people
I have seen it a lot.
That,
it's right up there with those people who say, let's not get the lawyers involved. They know what the bottom line really is. They don't want you to know what the bottom line is. And so they may appear to be being very generous. What they're doing is trying to stop you getting uncomfortable or desperate enough to go to court. So what they've done then is they've made you reliant on whatever it is they're giving you. And then people like that, the people whose exes have tied them up in this kind of gossamer web of spider's web, where if we go to court, if they know I've talked to a lawyer, my children's school fees won't be paid. They're going to go for more time with the children, and then, or they won't pay my rent or mortgage or whatever. So that is a little trap. A big trap, really. And the thing to do is go and find out your rights first so that you know that this isn't like this big, magnanimous, generous offer. It's not, it's just a little bit. And also, too, if they want to give you money, take it. Just don't sign anything.
Don't make any agreements. Oh, that's nice of you to give me the money. Okay, but we're still negotiating. So anyone listening today, have a think. Are you agreeing to things that you wouldn't have agreed to because you feel beholden to them, because you feel like they've been so generous and so helpful and so nice that it's somehow you have to, and that if you don't, then that will be revoked, because that might not actually be nice. That may be manipulative. Now, Mum, we've got time limit, so I'm going to get to the next one, which is weaponized urgency. This is if they suddenly give you the press, like they're like, you've got to sign this, there's a deadline, you've got to do this, or we're not going to do parenting. So they're really pushing you to sign the parenting or the property thing and pushing you with this deadline. Are there really deadlines when it comes to signing agreements?
Sort of, if you're in court. If you're in court, the court will impose deadlines. But outside of court, there aren't such strict deadlines. And if they send you something and insist on a response within 12 hours or 24 hours or whatever on a big issue, then it may not be a genuine proposal after all, and you are entitled to find out your rights. So again, I think your response would be, thank you for that. I'll consider it and let you know in a week or two. Okay, so their urgency is not your urgency.
Yeah, they're genuine. Then why would they only say 48 hours?
Yeah, because they want some more power. And also for you to not have time to think. Where I think the biggest pressure comes, I'm in the house with you and I'm not leaving. So as soon as you sign that, I'll move. And there's that. Yeah.
All right, let's quickly touch on personality types before we go to fire. So high conflict when it comes to sequencing between property and parenting. Which one, what usually happens? Do they do it together or apart? Should they do it together or apart?
I think do it together. You're going to have as much debate as it, and there'll be a lot of whataboutism. If you ask them about property, they go, what about this with the children? You might as well put it all in. You're heading for court anyway, I think.
What about avoidant? Which way should you work with them? They're more likely just to do nothing. So
they are.
You'd feel blessed if they just did one, at least two, let alone two.
So the thing with the avoidance is they often don't do the children's orders either, and there's no real harm in that. But if they happen to be in the house or you are tied up financially with them, you'll want to at least do property, and you might not bother. Your agreement for parenting may just lie in the fact that of what's been happening in their acquiescence or their failure to have time with the children. I'd go for property with that one.
Okay. Manipulative and controlling. So this is where the hostage swaps are in there, and also the what do we call that? The generosity trap happens.
Yes.
Should you do it separately? Does doing it separately take away some of their control, or should you be doing it together?
I think do it together. I would do it normally together because if it's children, there'll be a family report usually. And that family report, if it labels your ex as abusive or unable to support the kid's emotional welfare, then that will give you leverage to negotiate property and children going forward. Also, if you've been with an abusive person and it made your contributions harder during the relationship, then you might want to raise that in your property settlement as well. So it sounds awful, but the thing that they most don't want, manipulative and controlling, is someone to turn that light on and see what's in all the corners and see them for what they are. So I think do them both together.
Okay. And then amicable. Can you just do one and then the other one later? Can you keep it loose?
Yeah, you can keep it really loose. You don't even need a parenting plan usually if you're amicable. However, amicable doesn't always stay amicable. And as the kids get older and have points of view, or as they get a new partner or you do, things can change. So I think I'd want to put some sort of parenting plan in place, at least for a few years, with an amicable person for the children's matters. With the property, don't be misled into thinking that because you're kind and friendly to each other, that you will be able to bring closure to the property settlement. It often needs the push of a mediator, or you may need to play a little bit firmly or a little bit hardball because you're kind of separating the business of being a couple and running your lives. And so the other person might not see any urgency or reason, but from your point of view, you want that closure. You may have to do some gentle pushing. And if you're saying no to them and they get angry, well, you've got your answer there. They aren't amicable anyway. Yeah.
Okay. All right, let's do rapid fire. I love this. Putting short answers, Mother. Okay. They will not talk about money until parenting is signed. What's your first move?
Talk about the money. Bring an application.
Okay, there we go. We've agreed parenting between ourselves. Do we need to formalise it before we start property?
I think it's a good idea to at least get a parenting plan written down so that they can't change their narrative later on.
Okay. Can you do property now and parenting later?
Yep, you can. You can.
Does agreeing to more nights cost money?
I think it does sometimes in percentages. in adjustment. You will get less percentage adjustment in your favour if you've got the children less, and you'll receive less child support. But if you've got the children more, you get bigger percentage than you otherwise would have, and you will be paying less child support.
That is
less child support.
The one question I think why so many people say, I don't want to do property until I've done parenting or vice versa. So be mindful. That is a question that is running through some not very nice, thoughtful people. I'm asking that because but that is a question people think. Okay.
Mm-hmm. It is.
All right. We've already signed the parenting orders. Have I weakened my property position?
No.
Okay.
No. Parenting is in the best interest of the children, and the arrangement that you reach should have nothing to do with the property settlement.
Okay. Mediation is booked and they have not given me a single financial document. Do I still go? Okay.
Sure.
Court-ordered.
Unless it's court-ordered, and make sure that you can get a refund. You advise the mediator and the other person that you're withdrawing. And what I would do is say, if I haven't got all of the documents I need by 4:00 tomorrow afternoon, then the mediation is off and we will equally share the cancellation fees.
Okay.
Right?
Always get your own independent legal advice.
Yes.
Situation is different.
I bet you'll get it all the night before if you do that, though.
Yes.
And that's all right. It's disclosure.
Next question. They are refusing to engage at all. Is filing in court seen as aggressive?
I think you've got no choice. You can't just let them control you by doing nothing, them doing nothing. Your desire in this life is to move forward, to dissolve the property ties between you both and maybe the children's arrangements. And your desire to do that is perfectly normal and natural, and you should be allowed to do that.
And that's what it's there for. How long have I actually got? Just to recap,
married.
We've talked about this.
Yeah.
So if you're married, you've got forever.
Yeah, no, you've got until 12 months after you get divorced, right?
Yeah.
And sometimes watch out, the other party might file the divorce documents and suddenly you're on a 12-month rundown. If you're de facto, it's 2 years after separation. And I don't know how people are managing this separation under one roof business. We were talking to Coercive from Melbourne, and she said, is it really separation if they won't leave the house? And I think that might be part of the reason. So, be clear on the separation dates.
Okay. Now, these are the rapid fire questions for people who are in court. Okay. Can you seek parenting and property orders in the one application?
Yes.
Once you're in the list for court, what actually drives whether the two get heard together or separately? Is that your decision or the court's?
Oh, no, it's the courts, and they will be heard together. If property and parenting started off together, they'll be heard together. If you start property late, they'll run it up. They'll catch up and then hear them together. And it'll be one trial.
Does the court prioritise safety and children's issues first?
Yes.
Okay. Quickly talk about partial property distribution. Who is it for? What do you have to show for it? And why do so few self-represented people know it exists?
So the other side's never going to tell you that you could get interim property distribution. And if they've got lawyers, they're not going to tell you either. So what it is you getting some of the money that is rightly going to be yours in the future, just identify a property pool somewhere, some cash somewhere, and ask for half or all of that. And that allows you then to be able to get lawyers or to live in a less worried way, I guess, about your day-to-day expenses. And I don't know why self-represented people don't know it, but it's very helpful for people. And the court will say, if you're going to get at least that in the property pool, why not? So you send a notice of intention if they won't go to mediation. You go to court, you set your case out. And guys, don't accept them saying, oh, but I'll pay your electricity, I'll pay your rent, I'll pay this. No, you want your own money, a lump sum money. And if you need spousal maintenance, you can do that separately.
Okay. And last question for the rapid fire. If the other side is running that hostage tactic, the hostage swap tactic we talked about, does the court see it? Yes. And does it help them or hurt them?
Hurts them.
Okay.
Hurts them.
Yes. Okay. So keep your evidence if they're trying to do that. Make sure you've got any screenshots of where they've said whatever it is about hostage swapping with the key commas. All right. So lastly, just to tuck this on the end, because look, guys, it seems like a quite simple thing, but it is quite complex because everyone seems to think they become this master negotiator and they've read books and they've seen things and they want to manipulate, and it's horrible. But Mum, what would you embroider on a cushion for anyone who is trying to go through this particular drama where their ex is saying, I'm not doing property until we've done parenting, or I'm not doing parenting till I've done property? What would you say?
Yes. You can have a double-sided cushion. One of them can say, that's not the law. And the other one can say, who died and made you boss?
Awesome. All right, guys. And I need, write that on a sticky note. If you are one of those people that are being bullied, write it on a sticky note. That's not the law. And on the other sticky note, who died and made you boss? Because that's something you've got to kind of embody when you go through
this. Right. Yes.
Because it is, particularly from a feminine point of view, if you've been a people pleaser and all of that, I would just look up and go, oh, okay, that's what we're doing now. Okay. But no, this is your life. And unless it's in the law, then you can also be boss as well.
That's right. You're the boss of your life.
Yeah. All right. Thank you, Mum, for your time. And thank you, everyone, for listening. We will see you all next week.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.
A text says, you're on my mind. A bouquet from 1-800-Flowers says, you're my everything. Heartfelt moments belong in the real world, not just your phone. For 50 years, 1-800-Flowers has helped millions of people make memories that'll last a lifetime with gifts they'll cherish forever. Their expertly curated arrangements and gift baskets ship nationwide with a 100% satisfaction guarantee. Don't wait for the next big moment. Make it when you visit 1-800-Flowers.com/podcast. That's 1-800-Flowers.com/podcast.